right, so I should introduce myself. I'm Ethan Kleinberg. I'm the director of the Center for the Humanities, and I want to thank you all for coming out on this cold evening, and especially for coming out to support the lecture series all the way through on justice and judgment. This will be the last lecture in this. Actually, it's the last lecture of the year. And we'll start up again in the spring as we turn to the theme of audiences. But as I do before every lecture, I'm going to take out my phone and silence it in the hope that this will either be modeling and encourage you, or more likely simply shame you into doing the same, so that we have relative silence and we don't have buzzing and chirping and various other ringtones. I also want to remind you that we will be holding our colloquium tomorrow at 10:30 a.m. at the Center for the Humanities, which is at 95 Pearl Street, and you're all welcome to join us. We discuss the lecture that takes place. The conversation is usually quite lively and fun, so if you feel like coming down and delving deeper into the issues, please do. We'd love to have you. So it's been a really interesting and exciting semester that's taken us, if I remember from the very beginnings of it, from these discussions of global justice, the concept of global justice, and then we had our foray through aspects of both German idealism and dialectical materialism in search of notions of both justice and judgment through the Arendt conference. We even started thinking about the way things like our cell phones may have aspects of judgment, although they may know nothing about justice, as we talked about the cognitive non-conscious. We moved into discussions of racial theory, about the origins of perhaps this concept of race and how it's embedded in our understanding of history in the late Enlightenment. And then with Robert Bernasconi, we talked about other ways that these concepts seem to be smuggled along into our current usage, often without our deep interrogation into the ways they are operating in our current world. And so I feel like we sort of now are going to have a nice kind of chiastic effect in concluding the lecture with Professor David Palumbo-Liu, who we're really honored to have here with us today. He's the Louise Hewlett-Nixon Professor of Comparative Literature, and by courtesy of English at Stanford University. He began as a scholar of comparative literature, literary theory and criticism, and classical Chinese literature, and subsequently worked in the areas of ethnic studies, Pacific Rim studies, and social theory, and has published widely in all of these areas. I should also note that he's one of the founding faculty members of Stanford's program in comparative studies in race and ethnicity. And he's also committed as the founder of the e-journal Occasion Interdisciplinary Studies in the Humanities. And he's a contributing editor for the Los Angeles Review of Books. And most recently and fervently, he's been blogging for Public Intellectual Project at Truthout and for the Boston Review. Now, his most recent book is The Deliverance of Others, Reading Literature in a Global Age, which is immediately concerned with how literary aesthetics in particular help us meditate on the ways we are connected to and act in relation to others. And in that work, he reappraises the notion that narrative literature can expand readers' empathy, and he's keenly interested in the problematic of what drives our imaginations, especially of others, and what limits our imagination for both good and bad reasons. Thus, he is deeply interested in how literature helps us think through these judgments. And I think today we're going to see him, it may be a slightly different valence, but again, he's going to turn clearly to this question of judgment via the interrogation of justice in a post-racial world. So please join me in welcoming David Palumbo-Liu.
Thank you, Ethan, for that. That's one of the best introductions I've ever had. And I also appreciate the fact that the reception and the food is available before the talk, because you go to the talks and this announced there'll be a reception, and the speaker feels terribly guilty for standing between you and the food that you richly deserve, and especially coming up towards Thanksgiving, I feel it. So I invite you all to hit the buffet at any time during the talk, because I want you to be relaxed and well fed.
You're the most generous speaker we've ever had.
Oh, thank you. Yes, no, that's only right. So please do feel happy, feel free to wander about the cabin, as they say. I'm keenly interested in this question about how the imagination might or might not be able to help in rendering better and more just social judgments. I'll be focusing specifically on issues of race and of the particular issue of naming race as a factor in violent crimes. I'll take as my examples both a recent case, of which I'm sure you're familiar, the killing of Trayvon Martin and the trial of George Zimmerman, and another case that you may not know. It surrounds the 1982 killing of Vincent Chin in Detroit and the trial of his killers, Richard Evans and Michael Nitz. My main reason for discussing both these cases is that both call on us to use our imaginations to form judgments, and yet we seem caught in an impossible task. The legal bar that has to be met to render the judgment we would like to see is in these cases and many other cases nearly impossible to meet, precisely because our imaginations are simply that. They do not have the surety of fact that the legal case requires. And yet I'll be arguing that our imaginations are right if we factor in extra legal facts. Nevertheless, in this case, just being right gets us nowhere. We are forced out of what Arendt calls the political world and into the social world. And here I'm tempted to say merely social, for here the imagination lacks legal and juridical power. And yet I won't dismiss the social world entirely, and that is a theme I'll develop and leave off with as we launch into the discussion period afterwards. So my talk has three parts. First is a discussion of the verdicts in the trials of the killers of Trayvon Martin and Vincent Chin. And the second part will be a discussion of hate crimes as a way to map out the arenas in which grievances over violent crimes involving race exist in a gray zone between the political and the social, as Arendt has it. And I'll be using Hannah Arendt's essay on Little Rock to get to that, and then a brief closing remark on historicity and the imagination. In her 1959 essay on the 1957 case of Little Rock High School, the desegregation case, Hannah Arendt puts forward an interesting hypothesis. She says, quote, "The more equal people become in every respect, and the more equality permeates the whole texture of society, the more will differences be resented. The more conspicuous will those become who are more visibly and by nature unlike others. It is therefore quite possible that the achievement of social, economic, and educational equality for the Negro may sharpen the color problem in this country instead of assuaging it." Looking at present-day data, we find that Arendt is indeed correct. A recent report notes that, quote, "increases in hate crimes against particular groups appear to correlate with increased attention to that group, or even the perception of social progress in eliminating prejudice against that group, such as the national debate concerning immigration policy that began in the mid-2000s. As the Southern Poverty Law Center noted, quote, "FBI statistics suggest that there was a 35% rise in hate crimes against Latinos between 2003 and 2006. Experts believe that such crimes are typically carried out by people who think they are attacking immigrants. The immigration debate combined, in the minds of hate groups, with the worsening recession and Barack Obama's successful campaign to become the nation's first black president," end quote. This data and this insight should give us pause about the notion that we're living in a post-racial world. We should at least wonder what that term might actually mean. Shortly after the Zimmerman verdict was rendered, I posted a blog on Truth Out, and I'm just going to read parts of it, and then explain how my thinking has shifted somewhat since that time, largely because of Ethan's introduction to Think Through Hannah Arendt. But here's my first reaction, quote, Since the acquittal of George Zimmerman Saturday for the death of Trayvon Martin, there have been thousands of tweets, dozens of blogs. Some are relieved by the verdict, others try to explain the legal basis for it, but most are part of a collective scream of outrage and grief. Of these latter, the predominant feeling is one of disbelief. How can the facts of the matter not bring some sort of punishment for Zimmerman, any at all? How is he not guilty of taking the life of another human being who has done nothing to him of his own accord? As much as I get the legal reasoning, often delivered to us sanctimoniously and condescendingly by both legal scholars and those simply wanting to say the system works, that we just don't understand how fair it is, my reaction to the verdict is very much that of Lawrence Bobo, who wrote, quote, "The most elemental facts of this case will never change. A teenager went to buy Skittles and iced tea. At some point, he was confronted by a man with a gun who killed him. There is no universe, I understand, where this can be declared a non-criminal act. Not in a sane, just, and racism-free universe," end quote. A sensitivity to the deep and persistent history of racism and its ongoing destructive effects, and an understanding of the law often seem to be as mutually exclusive as oil and water. We are told we cannot let our emotions cloud the issue. We are given good reasons to constrain our subjective perception of things. In this case, we are told just to stick to the facts presented to the court. The problem, and this is something even legal experts admit, is that there was a paucity of evidence, and most of it came from the defendant's mouth. As the LA Times reported, quote, "Prosecutors could not prove Zimmerman was driven by ill will or hatred, the necessary elements of a murder case, when he got out of his vehicle on that rainy night and went after the teenager," end quote. Trayvon Martin was a young man just grown from boyhood. Wouldn't the jury have felt a certain amount of empathy? It could have been their boy or their nephew or their grandchild coming home with snack food, stalked by an anonymous man in the middle of the night, registering his fear to his friend as he spoke to her on his cell phone. But instead, to the shock and amazement of many of us, the jury seemed to side with Zimmerman. Was there not a weird inversion taking place here? The perpetrator became the victim. He was the one who was overcome with fear, and his suspicions and the actions that followed were warranted by the very presence of Trayvon Martin. When the defense team said they felt the jury would have acted as Zimmerman did, out of a sense of protection and standing one's ground, sadly, we have to say they were right. That the jury could not believe beyond reasonable doubt that Zimmerman was guilty of something, and that he deserved to be freed without legal consequence only goes to show how far our fears have sanctioned violence, not only against individual agents, but also against the racial stereotypes for which a young man like Trayvon Martin seems to be an example. Once the verdict was announced, I was dumbstruck. To simply say it shows that racism is live and thriving is not enough. To say that the legal system is racist is too broad and not subtle enough. What made Trayvon Martin's story irrelevant, muffled, erased? And why are we still living in a universe that is decidedly not a sane, just, and racism-free universe? And the issue is not just about our belief systems, what we take to be true or likely, it is rather how we then interpret how others act, and then how we act ourselves. That was the end of the blog. Well, after that came out, I was besieged on my Facebook page by friends, or mostly friends of friends, who insisted that the jury had gotten it exactly right. I spent some time saying that even though that might have been the case, there were more important things going on. But finally, after reading many legal experts' remarks on the verdict, I came to concede that the jury made the correct legal decision. As law professor Richard Ford wrote in an article in the New Republic, which was entitled, "The law that acquitted Zimmerman wasn't racist, but that doesn't mean the outcome wasn't." Richard Ford writes, "Zimmerman's acquittal might be the product of a racially biased jury, but in a sense, individual racism is beside the point. It's not at all clear that a colorblind jury would have reached a different conclusion. There were no witnesses to the events that led to this shooting, so no one to directly refute Zimmerman's version. Police mishandled crucial evidence, giving the defense an opening to discredit it. A very polished and credible forensics expert backed up Zimmerman's account, while the prosecution's expert seemed befuddled and uncertain. And perhaps most important of all, Florida law is extremely lenient with respect to the use of deadly force in self-defense. In many states, deadly force is justified only if the shooter could not retreat and avoid the confrontation, but in Florida, there is no duty to retreat. All this multiplied the possible scenarios that could justify shooting a teenager armed with a bag of candy and a can of iced tea. Nevertheless, Ford continues, quote, Zimmerman's acquittal raises the concern that black victims of crime don't count, and studies back up that concern. For instance, an important study of death penalty convictions found that a case involving a white murder victim was about 4 times more likely to result in a death sentence than one where the victim was black. And a study by the Tampa Bay Times found that defendants claiming stand your ground are more likely to prevail if the victim is black. 73% were acquitted as opposed to 59% of those who killed a white person. Ford argues that the deep flaws in the judicial system force poor minorities into a plea bargain with no trial, and that these and other facts of how the justice system works produce outcomes that are indeed racist while being totally legal. Here we have the argument that the legal verdict was legit, but the social, economic, and political world in which the legal system is embedded is decidedly racist. In sum, we have an outcome that is legally proper, but decidedly socially and ethically unfair if viewed extra-legally. Let's keep that paradox in mind, and I'll come back to it shortly. I want to cite one other legal scholar weighing in. After carefully moving through some of the key features of the trial, an article by Robert Weisberg ends, quote, I lack the wisdom or any distinct power of insight to add to the roiling debate about how race affected the case. Suffice it to say, in the United States today, perceptions of possible deadly threats are all too often race-inflected. Race blindness in resolving a case like this is impossible. Subtracting race from the case was a daunting challenge for the jurors. Race would have been implicit in the legal arguments and was sure to be unmentioned in the jury instruction. But the facts were these. Zimmerman knew Martin was African American. Martin may have made assumptions about Zimmerman because Zimmerman was a non-black confronting a black. And trying to surmise how Zimmerman and Martin perceived each other was crucial to this case. I bring up again Arendt, this idea of imagining others. So it's exactly here, with the question of perception and the centrality of the imagination in judging not only hate crimes, but indeed ascertaining the very presence of racial thinking in today's reputedly post-racial society, that I want to bring in the Vincent Chin case. I exhume this decades-old case not only because we have the benefit of a fine Academy Award-nominated documentary, and I'll show a couple of clips from it, to give us a strong sense of the stories that people told, narrating their first-hand experience of the violent crime and subsequent trials, but also because of the events that surround the case seem to be all too present yet today. And I'll tell you what the case is about. On June 19th, 1982, on the outskirts of Detroit, Michigan, an individual named Vincent Chin, 27 years old, an American citizen of Chinese ancestry and working class background, went to a strip club to celebrate his upcoming marriage. There he encountered 2 auto workers, Ronald Ebens and his stepson, Michael Nitz. After several drinks, Ebens was heard to make a remark aimed at Chin to the effect that, quote, you little motherfuckers are taking away our jobs. This is the middle of the depression of the auto industry and the fear about the Japanese imports taking over the industry. At that time, Chin swung at Ebens and by all accounts defeated him in the fist fight. Chin and his friends then ran out of the bar, pursued by Ebens and Nitz. They eluded their pursuers and eventually went to McDonald's to cool off and grab a bite to eat. Ebens and Nitz cruised the neighborhood in their car, offered passersby $20 to find that Chinaman, and eventually found Vincent Chin. Ebens went to the trunk of his car and took out a baseball bat and began chasing Chin. Nitz caught him, and as Nitz held Chin's arms behind him, Ebens swung at him repeatedly, clubbing his head in a fashion that an off-duty cop described as if he was trying to hit a home run. I'm just gonna play.
I was walking down the street from my girlfriend's house, and I seen some guys across the street over there. And you know, one guy, older guy, was checking the young guy's head, you know, because blood was running down his face. And went over to see if they needed any help. They said they needed some help, and they was gonna offer me $20 to catch these Chinese guys that they got into it with. So I said, okay. I said, do y'all want to go to the hospital? Because it was right around the corner. So we got into their car. The father was saying, you know, when we catch up with these Chinese guys, we're gonna bust their motherfucking heads like that. And as we got up to McDonald's, the father seen the two Chinese guys sitting down. And I told them that the police was there. They said, fuck the police.
At which time they jumped out, and it kind of shocked me. And because it's a predominantly 90% black neighborhood, and to see a male white get out of a car with a baseball bat, the first thing I was thinking that maybe it was coming from the Tiger Stadium baseball game.
Mr. Evans and Mr. Nitz jumped out from behind the truck, attempted to grab Vincent Chin, who they cornered up in the phone booth here.
Mr. Nitz had to grab Mr. Vincent Chin in a bear hug while Mr. Evans swung a bat, repeatedly striking Mr. Chin.
Evidently, Mr. Chin broke loose. He ran out here to the middle of the street, and he stopped. He slipped. Mr. Evans was standing over him with a baseball bat. He had it with both hands, and he was hitting him in the top of his head.
He swung the bat as if a baseball player was swinging for a home run. Full contact, full swing.
You know how they killed my son? One pushing the son, hold him up.
Held him.
Yeah, hold him up.
The son held him, yes.
The father hit him.
Yes,
the head. Kill my son, looks like it killed the animal like that.
Neitz and Ebens were both charged with killing Vincent Chin. I spoke with some of his neighbors, asked for reaction.
They're really good people, and it could happen to anybody. You know, it could happen to my husband, it could happen to anybody in my family. It's just one of those things.
If you lived across the street and somebody's like that living next to you, what are you going to say? No, you put me on the spot.
Well, the legend of Vincent Chin was probably best explained by Elizabeth when she came home from school. She's 8 years old. She's in the 2nd grade at that time, she was, and said, I found out what the Vincent Chin case is all about. She said, that's the case, my substitute teacher told me, where the auto worker who was out of work was so mad that he beat up this Chinese guy because he thought he was Japanese.
I think anybody who takes the time to go over the facts of this case and to read what people who are witnesses there, who have no motivation, no self-interest in coming forward and saying they overheard certain things, racial things. Anybody who takes the time to look at that, I think, can only conclude that there was racial motivation in this killing.
I'm no racist. I've never been a racist. I've never had anything against anybody in this whole world. And with God as my witness, that's the truth.
Vincent Chin died 4 days later without ever having regained consciousness. Remarkably, neither the off-duty security officer nor the police officers who responded to the court were asked to take the stand. In state court, Ebens and Nitz accepted a plea bargain. At the sentencing hearing, the prosecutors failed to show up. The judge gave each man 3 years probation and a $3,000 fine. After a large protest movement brought the case to national attention, the two were retried in federal court for depriving Vincent Chin of his civil rights. The first federal jury convicted Ebens and acquitted Nitz. The appeals court, rejecting the claim that Orientals are not protected by civil rights statutes, nevertheless reversed the conviction, and a second jury acquitted them both. Neither one of them spent a day in jail. Ebens insisted he was no racist, that he simply had too much to drink, that he just snapped. He said the whole incident was regrettable. He even conjectured, however, that it might have all been preordained. And I'm going to show this longer sequence that puts together all these multiple viewpoints, from Chin's friend, a juror in the civil case, two of the dancers who were eyewitnesses to the original, the first fight, and then Ebens himself.
Vincent called me at work and asked me to go out with him. He
So let's revisit the rhetorical question in the title of the film, Who Killed Vincent Chin? Read in the context of its making, the answer seems to suggest that both Ebens and Nitz, the courts, and the larger racist system of justice killed Vincent Chin. But if we press on, we can extend culpability much more widely to the social world of opinion found in the film and a world still in denial. For Ebens, I grant that he's partly right. It was a drunken brawl that went way out of control. But his question, I don't see how it could be racial, is key to the idea of seeing from the point of view of another. And in this case, as in many that seek redress for social wrongs, it's a matter of a social imaginary that's limited to not seeing beyond itself. And here I'm clearly evoking Charles Taylor's notion of a social imaginary, which he defines as, quote, the way ordinary people imagine their social surroundings. And this is often not expressed in theoretical terms, but carried in stories, images, and legends. The social imaginary is that common understanding that makes possible common practices and a widely shared sense of legitimacy, end quote. Now I hasten to add that I'm not entirely convinced that this imaginary is as common or consistent as Taylor depicts, but I take his basic premise as an object that we might test out tonight. Not unlike the jury in the Zimmerman case, there was a plausible and powerful counter-narrative to the ones presented by the prosecution in the case of the murder of Vincent Chin. And that is that in both cases, while race might have factored into the killings, other narratives, race-neutral ones, were more persuasive. That is to say, simply put, the social imaginary was and is raced. The race-neutral story was persuasive enough for the jury not to be convinced that race was the motive. There might have been anger, but no hate. It is in that murky area that hate crime prosecution tends to often flounder abysmally. And it's precisely here that a wide gap in our social imagination fails to lead us over into the realm of certainty. Or rather, let me correct that. Very few people I know, or whose opinions I saw in print or online, seem to have any doubt that they knew exactly what was going on in the minds of Trayvon Martin or George Zimmerman. And that's precisely the problem. Because we're used to, and indeed in need of, simple, declarative, easy to pigeonhole characterizations, we make easy but less than optimal judgments. And yet these judgments, while being less than optimal and having no legal bearing, are precisely part of the political world in which opinions should circulate for debate and contestation, according to Arendt. It is in the political realm that doxa and paradoxa move vitally. However, it's precisely because these discussions of race are more of a social nature than a political one that we reach a point of confusion and inaction. So let me formulate my thesis thus. In cases of racial violence, the critical and essential question of how to make the transition or conversion between the social and the political, between the vivid yet unevenly potent imagination of the social and the imperfectly potent realm of the political. Arendt often wrote about the capacity for truth to hold dominion over opinion, and that was not a good thing. For opinion was for her a necessity of a healthy democracy, the stuff of plurality, debate, self-reflection, as opposed to the dogma that's often contained in truth. And yet, in the world of social discourse, the imagination tends to retreat from the demands of plurality. In a passage that has surely been referred to often in the course of this speaker series, in Eichmann in Jerusalem, Arendt writes, quote, whether writing his memoirs in Argentina or Jerusalem, whether speaking to the police examiner or to the court, what he said was always the same, expressed in the same words. You listen to him, the more obvious it became that his inability to speak was closely connected with an inability to think, namely to think from the standpoint of somebody else. No communication was possible with him, not because he lied, but because he was surrounded by the most reliable of all safeguards against the words in the presence of others, and hence against reality as such. This notion pervades her thought. In her essay, Personal Responsibility Under Dictatorship, she again writes, it seems much easier to condition human behavior and to make people conduct themselves in the most unexpected and outrageous manner than it is to persuade anybody to learn from experience. As the saying goes, that is, to start thinking and judging instead of applying categories and formulas which are deeply ingrained in our mind, but whose basis in experience has long been forgotten, and whose plausibility resides in their intellectual consistency rather than in their adequacy to actual events. Let us say that the world of experience is no match for the hold of the social unimaginary. Here it's important to stress that when Arendt speaks of not being able to think from the standpoint of someone else, it is not just the other, but also a self unlike the self one is used to. That self shaped by conformity to the dominant ideologies of the time, and ones that in these cases go to the benefit of the accused. They seem merely to be following out the natural and rational choices of every man. In that sense, the consciousness of the other is deeply linked to being self-reflexive in a robust manner. In both cases, our judgment is colored by the challenge to the ways that we have been conditioned to think and the ways that coincidentally help racial ideologies be reanimated over and over again invisibly. Part of the erasing of race is brought about by the demands of the law in cases which we must prove some racial influence. In this circumstance, we employ our imaginations purposefully and strategically. To get to this issue most acutely, let me now turn to hate crimes. Unless provided with clear-cut evidence of racial motivation under hate crime laws, we need to be able to make a plausible case within the parameters of the legal statute per se. Quote, generally, prosecution under a hate crime statute requires that the individual committed some predicate offense set out in the statute with the animus specified in a hate crime statute, with the statute operating to enhance the punishment imposed for the predicate offense. End quote. That seems simple enough. But why is this particular animus something we need to target? We are no longer in the originary period of hate crime laws, which was shortly after the Civil War, nor even in the era of civil rights. The recent gutting of the key provisions of the Voting Rights Act is justified and even called for, according to Justice Roberts, because all the racist conditions that the Act sought to remedy are no longer with us. Look at that judgment. And yet hate crimes stay on the books. Why? Hate crimes need to be seen as having a social life as opposed to merely having a political or legal existence. One legal scholar makes the crucial point that, quote, hate crime prosecutions are society's way of demonstrating abhorrence for the specific wrong done to the victim. How society reacts to one's victimization can be seen as by one as an indication of how valuable society takes one to be, which in turn can be viewed as an indication of how valuable one really is. End quote. This notion that alongside or even beyond legal punishment, there can be an excess of blame, abhorrence, emanating from the social world that may or may not find any legal recourse is found in Arendt's comments on the prosecution of war criminals. I admit the analogy is not exact, but I want us to focus on this idea of social abhorrence that is over and beyond what can neatly be contained within the law and judgment. So, Arendt raises, quote, the question of legal punishment that is usually justified on one of the following grounds: the need of society to be protected against the crime, the improvement of the criminal, the deterring force of a warning example for potential criminals, and finally, the attribute to the justice. And then she says, quote, a moment of reflection will convince you that none of these grounds is valid for the punishment of so-called war criminals. These people are not ordinary criminals, and hardly any of them can reasonably be expected to commit further crimes. Society is in no need of being protected from them. And then she goes to show many other examples of how prosecution of war criminals just doesn't fall under the usual legal reasons for prosecution. She concludes, here we are demanding and meeting a punishment in accordance with our sense of justice, while on the other hand, the same sense of justice informs us that all our previous notions about punishment and justification have failed us. Now, it's precisely here that we get into murky waters, for, as those of you who know the Little Rock essay, the idea of a mandated social rather than political mode of justice is something that Arendt opposes. She writes, segregation is discrimination enforced by law, and desegregation can do no more than abolish the laws enforcing discrimination. It cannot abolish discrimination and force equity upon society, but it can and indeed must enforce equality within the body politic. For equality not only has its origin in the body politic, its validity is clearly restricted to the political realm. Only there are we all equals. What equality is to the body politic, its innermost principle, discrimination is to society. Here's where she makes that very weird move. Society is that curious, somewhat hybrid realm between the political and private, in which, since the beginning of the modern age, most men have spent a greater part of their lives. For each time we leave the protective four walls of our private homes and cross over the threshold into the public world, we enter first, not the political realm of equality, but the social sphere. We are driven into this sphere by the need to earn a living, or attracted by the desire to follow a vocation, or enticed by the pleasure of company. And once we've entered it, we become subject to the old adage of like attracts like, which controls the whole realm of society in the innumerable variety of its groups and associations. What matters here is not personal distinction, but the differences by which people belong to certain groups whose very identifiability demands that they discriminate against other groups of the same domain. Without discrimination of some sort, society would simply cease to exist, and the very important possibilities of free association and group formation would disappear. So there are three realms in Arendt. Equality is the proper business of the political realm. The private sphere is what goes on behind closed doors, and is the business of the people behind those doors. In this case, she's critiquing anti-miscegenation laws which attempt to legislate the private realm. The third realm, the social, is a murky hybrid space between the private and political. Here we might see social groups or collectives as endowed with some of the rights of the private sphere, even though the social, of course, lives outside the bounded space of the private. As part of that private right, groups may enjoy the right to bar others from private clubs, for example, or all women colleges, or permissible, or all black colleges as well. People have a right to discriminate, and even the obligation to do so. For without that power, they are too readily merged into an indiscriminate body. Arendt wrestles with the issue of school desegregation. She acknowledges the role schools play in social advancement, but then downplays it. For her, the more important right is the social right to discriminate. I'm going to leave that debate aside as I close out this talk, for what's more important for today's talk is to probe into this social realm. Again, it is within this realm, nestled alongside the political and the private, that both the right to discriminate and a sense of extra-legal justice abides. The paradox is that just as the social should not only entertain but also nurture discrimination, so long as that discrimination does not filter into the political or private, infringing upon the rights of the individual or the group, it is sanctioned by Arendt. And yet it is precisely in Arendt's social realm that prejudice and discrimination live. And even more bafflingly, it is in the extra-legal world of the social that extra-legal sentiments of abhorrence can and should exist, as is painfully evident in the case of war criminals. In that discussion, Arendt acknowledges the need for some way for society to express its hatred of hatred that goes beyond the political and the legal. This finally calls for a renovation of the political realm. We find, instead of a clear-cut separation of the three realms, then, a movement of interpenetration brought about by historical contingency. In conclusion, for Arendt, the notion of separate but equal is a political and philosophical solution, but as yet an untested historical one. Two issues emerge, again historically and imaginatively. First, the flaw in Arendt's firewalling of the social from the political is that she radically underestimates the non-neutrality of the system that Richard Ford notes, and secondly, she underestimates the permeability of the social and the political. She still wants us to devote energies to the political solution. She wants to deliberate and debate freely in the social realm, and then have what is deemed proper to hand over to the legal system be mandated as the consensual will of society. And yet, the question about the legally invisible and thereby unprotected minority remains. Or let me correct that. The legal protections are there, as we see in the two cases that we've just looked at, but the social imaginary, so necessary to interpreting the law fairly, continues to come up short. This, coupled with the real structural inequities of the legal system, should give us pause about the notion of a post-racial age and compel us to indeed work to both generate a new social imaginary and, crucially, convert a new sense of justice into the political realm. I suppose it boils down to whether you're an optimist or a realist. The question of the possibility for any of this to happen weighs on our imaginations and our political will. Has the time come or has it gone? Thank you.